Doug is a member of the list. He came to the bar in 2005. He practices in the area of alternative dispute resolution, mediation, trade practices, franchising, commercial law, consumer credit, public law, merits review, licensing, guardianship and administration. Before he came to the bar, he was a solicitor at Minter Ellison's and he specialised in competition and consumer law, including franchising. He's also a qualified economist and a company director and has worked in senior roles in the ACCC. I think he's also chairman of South East Water, so he's comes as the full bag in terms of experience, and he's a director of Watermove Proprietary Limited and Tintern Schools.
Thanks, Michael. Thanks, Kate. You've got a pack of PowerPoint slides. They're pretty information. I was going to say they're pretty dense. That might be because I wrote them, but no, there's a fair bit of information in there, and really I'm going to try and avoid just trying to read those slides, and I'll try and sort of just come to a couple of points which I think will be useful and that you can take away with you. In my experience at these things, if you can go away with a couple of insights, that's probably not a bad result. The information in the slide pack you can always refer to later on. Amongst other things, really the slides consist of a couple of mud maps, and those mud maps are really about what I regard as, for the general ruck of legal practice, the very common issues that you'll tend to touch on in terms of consumer, not consumer credit, but the consumer provisions in the Australian competition law. So it's titled From the Unfair Practices Provisions of Part 5 of the TPA to the ACL, and the recently introduced provisions about consumer guarantees, and it'll be misleading and deceptive conduct, unconscionable conduct, and consumer guarantees, which were, of course, previously the implied warranty provisions that I'll be talking about. Okay. The objective of introducing the Australian competition law was really about streamlining things, and as all legislators do, it's questionable whether or not they achieved that result. The press release from Emerson in relation to the bill was that the Parliament had last year passed the most comprehensive changes to the Trade Practices Act since its inception in 1974, and that it was a complete modernisation of consumer protection laws, and that the new Act would transform fair trading and consumer protection laws, replacing inconsistent provisions in what were previously 17 separate Commonwealth, state and territory laws with a single national law. Now that's significant. I'll talk a little bit about how you might frame particular cases or causes of action, because the transition from the previous arrangements to the current arrangements and how you might manage cases where the circumstances fall over those periods are significant. The other thing which Dr Emerson emphasised was that the new Act created a clearer, simpler set of statutory consumer guarantees to ensure consumers understand their rights and were not ripped off by suppliers of substandard products. So that's sort of, if you like, the second part of the presentation that I'll be concentrating on. By way of background, since 1 January 2011, the Trade Practices Act no longer exists, so we refer to the Australian Competition Law, and that is an amendment to the Competition and Consumer Act. Well, sorry, it's not an amendment. The amending act was the Competition and Consumer Act 2010, which actually has now done away with the Trade Practices Act. Now, that'll only be significant insofar as you will still have to refer to the Trade Practices Act with regard to some actions. Significantly, the new regime has preserved a lot of things that you might have seen previously. So the application definition provisions of the old Trade Practices Act are preserved. Part 3A, which is the access provisions, is preserved, and Part 4, which are the prohibitions on restrictive trade practices, including what Ian was talking about, has been preserved. So that all sort of stays there the way you're used to seeing it. But what's actually happened is the movement of the consumer law provisions, which is what you knew as Part 5 of the Trade Practices Act, has now become Schedule 2 to the Competition and Consumer Act. So that's the thing to be aware of. In terms of the general outline, you can really read that for yourself, but It's useful, I think, because if someone comes to your office or whatever and they've got a problem, the idea is to be able to sort of categorise it. And so at least I've found this general outline is helpful in terms of actually where might you slot someone in. Someone turns up and they're talking about a pyramid scheme or something like that. You just know that you can find that in Chapter 3. It's easy to find your way there. But the critical thing, of course, is you've got to start out at Schedule 2 of the Competition and Consumer Act, because that's where the ACL resides. Now, to a bit more detail. Now, the things that I really wanted to emphasise about this slide is, with respect to consumer guarantees, I'll be talking about those separately, but what they demonstrate is that in some instances you now have multiple provisions under the consumer law, whereas you previously only had one provision under the Trade Practices Act. And similarly, if you go through and you cross-reference all of the various provisions, you'll find instances where you previously had multiple provisions under the Trade Practices Act and you now only have one under the consumer law. So the issue is really, there's nothing sort of scientific about this, but you do need to spend some time trying to trace these things through when you're framing a case, or particularly at least at our pointy end of things, if you might be pleading a case. The other thing which is very commonly happens around these types of proceedings is that the parallel provisions in the ASIC Act will be pleaded, and that's generally been done in the past in a sort of a shotgun approach. Now, one of the things which you don't really need to do going forward, if you think about these claims carefully and if you frame them carefully, is that you often don't need to plead that broadly, because the Australian consumer law is enforceable by all of the federal courts, it's enforceable by all of the state courts, it's also enforceable by all of the state tribunals. So you can simply rely on the Australian consumer law now as being the overarching law, and you can choose your jurisdiction. Whereas previously, if you, for example, had an individual involved in something, you would have had to go under the Fair Trading Act, and that would have had state jurisdiction issues. But to try and get it in the feds, you might have gone under the ASIC Act or something like that. Those issues about how you try and manage the jurisdiction which you might bring a proceeding in have really fallen away by and large, because the Australian consumer law is enforceable in all the state and federal jurisdictions. So you no longer need to plead in the case where you might have had an individual who you're making allegations against as well as a corporate entity. You no longer have to plead the Fair Trading Act provisions as well as the Trade Practices Act provisions. You can just go under the Australian consumer law against both of them. A couple of significant things. With respect to misleading and deceptive conduct, it's now Section 18, whereas that previously was Section 52. That's, in my experience, one of the most common, that's the common touch point really, if not the most common touch point for most practitioners in this area. So Section 18 is the one that you want to be looking to. Now, if you're looking for a bit of an explanation about sort of Section 18 and its inception, the best place in my experience to find this material is actually the explanatory memorandum for the bill, and that's an extremely detailed explanatory memorandum. There's a chapter for just about all of the various sort of important things, and those chapters actually contain their own mud map which reconciles the various provisions, so that's very useful. But what it makes clear, I think, is quite interesting, and there was some suggestion that this might have changed, was that Section 19 actually maintains the exemption for conduct where your client might be merely acting as a conduit. So the question will always be, in terms of misleading and deceptive conduct, and will remain the case, whether or not the representations made are actually representations made by your client on their own behalf, or whether they're merely, if you like, firing the rifle and someone else prepared the bullet. So cases like John Bevan's, NRMA, and the cases about where the line is drawn between responsibility for making the representation and just merely conveying the representation, they remain pretty important. So if you've got any clients around that sort of area where they might be involved in publishing other people's representations, they remain pretty important. The other significant and common touch point is around unconscionable conduct. Now that's sections 20, 21 and 22 under the new Australian competition law. But significantly, there are infringement notice provisions in relation to section 20. Now, it's going to be interesting to see how these play out, in my opinion, because the infringement notice provisions are really only available if you couldn't satisfy section 21, which is, of course, the business to consumer type of unconscionable conduct, what used to be 51AC, and section 22, which used to be 51AB, which is the business to business type of unconscionable conduct allegation. So it's going to be interesting to see how that plays out over time, in my opinion. It's going to be, if you like, I think it's going to be quite complicated because really that provision is sort of the more general law type of concept of unconscionable conduct, which is probably actually more assailable in terms of challenging whether or not that conduct has in fact existed. A couple of things in terms of framing your case. What is very clear from the explanatory memorandum and the new provisions is that there's three, if you like, relevant sort of sets of time considerations. And the first is where you have conduct which predates the 1st of January 2011, you are under the old regime. So if you want to go against an individual and a company in relation to misleading and deceptive conduct or unconscionable conduct, and that conduct predates the 1st of January this year, you're back to running it with reference to the Trade Practices Act and the relevant Fair Trading Act, or whichever of the other 16 state acts there are in Australia. So you really need to be mindful of that. Any conduct which occurs after the 1st of January 2011 is quite clearly under this regime. You need to be mindful of that. But the other thing which you really need to be mindful of, and I haven't seen an example of this, but I can envisage one, and one will turn up before too long, is that where you might have conduct which covers both of those time periods. A belt and braces approach to that would be to simply say, well, okay, we'll plead the case by reference to the previous provisions, insofar as some of the conduct was in that period, and then we'll have to plead the case by reference to the new provisions insofar as there's conduct in the time period after the 1st of January 2011. Now, really that is just a belt and braces approach, because of course you could probably arguably shop it into either time period. There's not a significant difference in my view as to how these laws will play out over time, so that might be something that your client wants to do. But for the sake of being comprehensive, you really need to just think about that. And I'll talk about a couple of war stories if I have time in relation to why that might be an issue. Now, the second really significant, or I shouldn't say the second really significant, I'm sure there's a lot of really significant amendments which were made, but I think for many people who sort of, as I said, in the general ruck of legal practice, the second very common touch point with the Australian consumer law will be where solicitors have a client that comes in and they say, oh, you know, look, it wasn't fit for purpose, or, you know, they told me to do something that it wouldn't do. So this is the old implied warranties and conditions provisions, and we've all seen stacks of cases and stacks of matters which involve these provisions. Now again, there's issues about how you frame your case, and I think that they will be important. Really, as I've said there on the slide, these are those old sort of chestnuts. What is really happened here, which is significant, is that previously the arrangement was that there was a, if you like, a different kind of onus. The application was not to be excluded or modified, but now, under Section 64 of Schedule 2, the guarantees are not to be excluded or modified by contract. And really, that might sort of sound, you know, pretty much the same thing, but there's a subtle and important distinction, and that is that the previous arrangements were conditions and warranties. So, whilst it wouldn't have mattered in perhaps some of the inferior courts, because you might be dealing with people that weren't as familiar with the matters as you were, you could have avoided the subtleties of pleading. But in the superior courts, it's very important because you actually had to allege the breach of the condition or the warranty, and then you had to actually plead by reference to Section 82 the damages which are flowed by reason of the breach. What's actually happened now is that the provisions are consumer guarantees in the legislation. So the remedies are in the legislation. You don't need to actually plead the way that you used to, and you don't need to think about the case the way that you used to, where you would have to, if you like, try and prove the breach of the condition or the warranty, and then you'd have to try and prove damages. The remedies are now in the Act, and so that should make it significantly easier, in my opinion, to actually try and conceive of some of these cases. The provisions apply to all supplies. So this includes agreements to supply, and any goods supplied after the 1st of January 2011 will therefore be caught up in the provisions. One question as to how this might apply, which I think is, perhaps it's a little bit academic, but it's worth considering again in terms of just how you would apply these going forward. There seems to me some doubt, I think, really whether the current TPA implied warranties regime or the new regime will apply to goods and services where there's an agreement to supply entered into prior to the 1st of January this year, but there's delivery after the 1st of January this year. In my view, it's not clear. The transitional provisions under Schedule 7 of the ACL don't really contemplate this situation, in my view, so you need to sort of think through it yourself. And I think the arguable approach really is to say, well, it's likely, and if not likely, it's certainly arguable, that both the TPA implied warranties regime and the consumer guarantee provisions under the Australian consumer law are likely to apply to such goods or services. So I'd be approaching it that way, where you haven't got clarity about the actual timing of the issues there. In terms of the application, it applies to acquisitions by a consumer. There's an error in that slide, I'm sorry, it's not costing less than $40, as I'm sure all of you know, it's less than $40,000. Or the goods must be goods or services of a kind or quality for personal, domestic, household use or consumption. Now, people who've been reading a lot of the cases will know that under the previous Trade Practices Act regime, there was some argument, there were some cases where people had actually dealt with commercial conduct and they tried to frame it within the provisions of implied warranties and conditions by actually saying what's would be of a kind normally for personal, domestic, household use or consumption. Nothing's really changed there. If you've got a client and you've got a transaction which might be more than $40,000, it's still the case that you should actually consider whether or not that's one way of trying to shoehorn it into these provisions. And there are cases, for instance, with respect to carpet, where the court's held that carpet, for example, is normally for personal, domestic, household use or consumption. And so commercial quantities of carpet have been shoehorned into these provisions in order to try and get relief. So those types of options remain available for you. In terms of the application to what sorts of transactions, the transactions remain transactions in trade or commerce. I've heard some discussion about whether or not this new arrangement picks up second-hand goods. I've heard pretty good arguments, I think, both one way and the other way. I'm probably not going to express a view, but I think if I had someone send me up a brief to advise, I reckon I'd probably say at the moment that it's coming down where this could actually include second-hand goods. It certainly doesn't include, in all instances, goods bought at auction, and that's relevant to a couple of the things that I'll be saying a little bit further on. But by and large, no private sales in trade and commerce. Make up your own mind whether the reform objective of things being simpler has been achieved. Okay, with respect to goods, this is really just a table of the relevant provisions and how you sort of trace them from the TPA to the ACL. And there's no really significant changes except with respect to section 54, which was previously section 71 of the TPA in relation to acceptable quality. So what's the test there? Well, the test, and I think which is interesting and what's arguably changed, is that the test now is the goods must be fit for all purposes that goods of that kind are commonly supplied for. Now again, this seems to me to be extending potentially the notion of sort of the boundary around what's ordinarily for personal, domestic or household consumption. So if you can sort of make an argument that there's a common use for particular goods there's a chance that you can shoehorn them into these provisions. There's acceptability in terms of appearance and finish is a slight broadening, in my opinion. Heavens knows how that's going to be determined going forward, but I suppose we all got different views about what's acceptable in terms of appearance and finish. Free from defects, they must be safe, nothing new there. Durable, again, this is going to be a bit of a grey area, I think, going forward. But more importantly, acceptability is going to be determined by reference to what's described as what a reasonable, fully acquainted consumer would regard as acceptable. Now, if that is not just a can of worms waiting to, be opened up, well, I'm just looking forward to the brief that lets me open up the can of worms, because what a reasonable, fully acquainted consumer would regard as acceptable is, I think, at large. There is some guidance, however. The meaning of reasonableness has regard to the nature of the good, probably nothing earth-shattering there, the price of the good. Now, I think there's a bit of a grey area going there potentially, because, should the fact that something's cheap mean that it can be junk? I don't know that that's going to fly. But there is some relativity there around the price and the relationship between quality and price. Any statements on packaging and labelling, well, that's nothing really surprising there. And representations of the suppliers or manufacturers. Now, I think that is potentially a bit of an interesting issue, because what it's suggesting to me is that there's this potential overlap now between the misleading and deceptive conduct provisions, and in particular the misleading representations as to quality and things like that, which used to be under Section 53. There's now some overlap between that and these consumer guarantee provisions. So you might just want to consider, if you get someone that comes in the door, with a particular problem, saying, "Oh, look, they were, whatever it was no good, and they told me it was going to do such and such," you might actually have multiple causes of action, whereas previously you might not have had multiple causes of action. So I think that's one there just to keep a bit of an eye on. Okay, consumer guarantees with respect to services. The significant change which I wanted to draw to your attention there, and I think it's one worth taking away, is that there is now a new provision, Section 62 of the Australian Consumer Law, which says that services must be supplied within a reasonable time. Now, there's going to be tension between that and the new, or the, if you like, the new arrangements with respect to express warranties, which say that where there is an express warranty, you can by and large rely on it. What this provision is saying, that if there's no express warranty, there has to be this supply within a reasonable time. Now, the obvious solution, of course, is for people who've got commercial practices as well as litigation practices, is to wind all your clients up and get them in and make sure that now their agreements have express warranties in them. Because what a reasonable time is, I don't know, there's no case law as to what a reasonable time is in this context. It's a new provision. So you're going to have aggressive litigants out there who will just really, we've all dealt with them. They'll have a view on what's reasonable and what's unreasonable, and they'll want to charge off, and your client might end up on the other end of it. So there's a couple of lessons. One is that you now have this provision, which means that you might have a client that comes in who says, "Oh, look, they said they were going to repaint my roof. I paid them $1,000 deposit, and that was in 2007. Probably some issues about whether that was a reasonable time. But there's also going to be issues where your client is going to say, what about a landscaping contractor or someone like that who's providing services ordinarily for personal, household or domestic consumption? What's a reasonable time in that context? Well, Mr. Landscape or Mrs. Landscape Gardener, come in, we'll get you an express warranty. And of course you can limit the scope of these consumer guarantees to a replacement or remedying the services, something like that. So important sort of implications there for your clients, I think, going forward. And the lack of authority means that you really need to consider the facts of each particular situation and the circumstances of your particular clients. Now, as I mentioned, the remedies are contained in the Act now, and you don't need to worry about pleading the breach of conditions or warranties and then alleging Section 82. Basically, there's two streams of remedies. If a failure is not major and it can be remedied, then the provider has the opportunity to remedy. If they fail to remedy, then you can claim damages. The alternative proposition is that there's a major failure or the failure can't be remedied, and then you can reject the goods, and your client actually has an election where they can get a refund or a replacement. Now, that is a little bit different. Significantly, any associated services contract can be cancelled and a refund can be recovered for services paid. Again, I think this is going to evolve over time, but the one that at least came to my mind, courtesy of a teenage daughter who'd had a similar experience, was what do you do about a mobile phone where you've got the actual phone and you've got an associated services contract? Now, if the mobile phone breaks, does that mean you've got an opportunity to get out of the associated services contract? I don't know, but it's an interesting question, and no doubt that's a question that's going to be tried around these provisions. Okay, a little bit more on the remedies. Just some guidance in terms of major failures and failures to remedy. If the goods or services wouldn't have been acquired by a reasonable person acquainted with the failure, that may be basis to actually say, well, this is a major failure. Now, again, it just seems to me that the language here is pretty unhelpful, because what's actually happening is that we're talking about a reasonable person with this sort of acquaintance with the goods. Now, if they're going and getting the goods for the first time, they've got no acquaintance with the goods, arguably, or perhaps they've gone and read Choice magazine or something like that. I don't know. But it's a bit speculative, really, how that all might play out. If the goods depart in a significant respect from the demonstrated goods or the described goods, then that will get you arguably within the major failure provisions. If the goods or services are substantially unfit for a purpose that they're commonly supplied for, and they can't be fixed within a reasonable time to make them fit. Now, really, what that is about, I think, is if you consider that what's very commonly done is in drafting these warranties, you'll try and exclude anything beyond the fact that you can replace or repair. This is really creating some tension about what's the value of those actual provisions and those restrictions in your commercial agreements. So I think there's probably going to be a bit of law develop around that going forward. The goods or services for a disclosed purpose made known to the supplier and they can't be remedied within a reasonable time. Similar kind of issue. Or finally, that the goods are not of an acceptable quality because they're unsafe. Nothing new there. Or supply of them creates an unsafe situation. Now, I think there might be a bit of scope to argue what is the creation of an unsafe situation, if you like, by reference to the supplying of goods. So that'll play out over time. But significantly, and the one, or at least in respect to this area, the one thing which I think is worth taking away is that this is a sort of empowering provision for the consumer, and this is what Emerson was talking about when he was talking about the benefits for the consumer of these provisions, that the consumer now has the right going forward to elect a refund or a replacement, and they can also recover for loss or damages which were reasonably foreseeable as a result of the failure. And you can go against both the manufacturer and the supplier. So I guess just speaking at a theoretical level, there's a question about whether or not, if you think back to Section 82, the measure of damages was damages caused by the conduct. Is lost damages reasonably foreseeable as a result of the failure broader than Section 82? Again, this is something that will probably develop over time. So I can't give you any indication there, but it must be at least arguable, if we're sort of out there on the edge of the envelope curve, that we can push some of these ideas in terms of what you might recover for a client who's trying to recover losses or damages, and alternatively, the types of things that you might have to resist when you get other people pushing on your client. Okay, now, just very, very quickly, I don't know about questions because, as I said, I've got to go off to court. We might have time for a couple of quick ones. But just a couple of war stories. I received a brief yesterday which actually related to conduct in 2008, which attached the Australian consumer law. And the memo from the instructor to the client referred to the Australian consumer law. Now, quite clearly, we all pay PI for very good reasons. But with respect to conduct in 2008, the relevant law is not the Australian consumer law. The relevant law was the Trade Practices Act and or, in Victoria, Sections 8 or 9 of the Fair Trading Act, New South Wales Fair Trading Act, and various other jurisdictions accordingly. So be careful, because there's a lot in the media including, you know, the government telling us what a great new wonderful world we've got. But you still need to actually work out when did the various events occur and how do I apply the particular provisions. So the actual transition of those provisions is going to be significant over time. I also saw recently in a mediation where I was in the federal court, where someone actually asserted that our claim, which relied on the Trade Practices Act and was quite clearly conduct which was within the Trade Practices Act regime, that we couldn't proceed with the mediation on the basis of that. And it actually, if nothing else, it took a little bit of time just to persuade the other people by reference to Chapter 3 of the explanatory memorandum that quite clearly we did have to proceed under the Trade Practices Act, and if we hadn't proceeded under the Trade Practices Act, that's when we would have had an issue. So there's just a couple of little war stories which are emerging there. In terms of the sort of scope of damages and things like that, I think I can't really give you much guidance. The point, I guess, again, just trying to think of what's the point to take away, is that the timing and application really will be important because we're already in June from the 1st of January 2011 Australian competition law. Now, very, very quickly it will become the case that there'll be two regimes that you need to have in your head. And so if nothing else, I hope that these little mud maps are useful in terms of that, because you will, very, very quickly, you'll have people come in and they'll say, well, okay, look, this is when it happened. Well, hang on, competition law, ACL or TPA. And so the ready reckoners hopefully can sort of at least help you deal with that and work your way through it. I think the other thing which is going to be interesting is whether or not you get larger cases where there's a course of conduct which will extend between both regimes. That's going to be interesting to see how the law develops there. And I think the damages provisions, which are a little bit easier to manage, and those consumer guarantees. So, as I said, I really just hope there's a fair bit of information in the pack, but I just hope that there might have been a couple of points that are worth taking away. That's it for me.
Doug, I'm thinking more from the acting for a manufacturer, you're drafting an agreement, supply of goods, and can't quite get the wording right, but there's that clause that says that if the goods are defective and they're returned, the maximum liability of the manufacturer at his election is to repair the defective goods, return them, replace the defective goods, provide similar goods, you know, and that's the limit of the liability, we used to say, under the Trade Practices Act. Are you aware that? So I'm acting for the manufacturer, so I'm trying to limit the total exposure under what was the Trade Practices Act. Now, is that, in your mind, followed through under the new Act, or there's some things you certainly can't exclude certain liabilities under the legislation?
Well, I think there's two aspects. Sorry, I think there's two aspects of that. One is that under the previous regime, you couldn't contract out of those provisions. The way that the Australian consumer law works is actually that they're part of the contract. So it just means that you can't not include them in the contract. In terms of what you're actually talking about, you're really talking about what's the extent to which you can carve out liability. And in my view, and until there's some sort of case law around it, the extent of the carve-out's the same.
So, Doug and Ian, thank you very much for your time and your expertise this morning.